Hi, I am Gurjeet Singh from Guru Gobind Singh Indraprasth University. Today we are going to discuss an important module, that is liability of internet service provider. Now we know that internet service provider plays a very important role in the functioning or accessibility of internet, and therefore at many of the time when many of the legal issues are being created on various other aspect of internets or cyberspace, many of the time ISP is also party to cases, and therefore we need to understand what are the liabilities of ISP when they are providing internet connectivity or when they are providing connectivity to the cyberspace. The overall objective of this module is to understand the concept of internet service provider, to second to discuss or to understand the justification of imposing any liability on ISP, if any, for the third party information, then to understand the various approach relating to liabilities of ISP, and by doing comparative study of USA, European Union and Indian laws on the point, and to see what Information Technology Act of India, apart from intermediary guidelines rule of 2011, has to say on the liability of internet service provider. Now starting with the definition of internet service provider. Ironically, the internet service provider definition has not been provided in any international convention so far, because there is no convention on this point so far. Second, from Information Technology Act perspective, there is no definition of internet service provider, though there is a definition of intermediary. Now it says the definition of intermediary as per IT Act is, it says with respect to any particular record, means any person who on behalf of another person receives, stores or transmits that record or provide any service with respect to that record, and include telecom service provider, network service provider, internet service provider, web hosting service provider, search engines, online payment sites, online auction sites, online marketplaces and cyber cafes. So you will see this particular definition has two important parts, or we can divide it into two important parts. The first part of this definition is basically talking about different functions or the important function which internet service provider or intermediary does. And in the second part of the definition of intermediary, it talks about 9 different kinds of intermediary. Internet service provider is one such intermediary. An intermediary is nothing but a facilitator which provides internet connectivity, or which store, transform or transmit information on behalf of someone else. So that is how Information Technology Act define intermediary. Coming to European Union in search of the definition of internet service provider, they have directive principles relating to e-commerce, and the directive defines service provider, and it says the service provider can be a natural or legal person providing an information society services. It defines information society services as any services normally provided for remuneration at a distance by means of electronic equipment for the processing, including digital compression and storage of data, and at the individual request of a recipient of a service. Now, this definition to some extent define the role of internet service provider, that they provide the services on subscription or remuneration basis on the request of the recipient of the service, and they provide the service of electronic equipment, or they process the information on the request of recipient. Then Organization for Economic Cooperation and Development makes an attempt in 2011 to define the internet mediatories, and it defines it this way. It says internet mediatory bring together or facilitate transactions between third parties on the internet. They give access to host, transmit or index content, product and services originated by third parties, or the internet or provider provides internet based services to the third parties. So, to some extent it is a comprehensive definition of internet intermediary. As per this definition, these are the following rules of intermediary. The first one is to provide infrastructure to collect, organize and evaluate disperse information. Next, to facilitate social communication and information exchange, to aggregate supply and demand, to facilitate market process, to provide trust, to take into account the needs of buyer and seller and users and customers. Now, in pursuance of the definition of internet service provider, the US has drafted in particular the Digital Millennium Copyright Act, and it defined service provider as an entity offering the transmission, routing or providing of connections for digital online communications between or among points specified by a user of material of the user's choosing without modification to the content of the material as sent or received. Now, so far this is the most comprehensive definition of internet service provider, because it talks about the important functions of internet service provider, that is transmission, routing and providing connection for digital online communication. And it further says that the material which is being transmitted or made accessible is dependent on the choosing of the recipient, and it is without any kind of modification from the service provider. Now, that is the main function of internet service provider as per the definition of Digital Millennium Copyright Act. So, therefore, the important functions of ISPs are that ISP may operate at local or reasonable or regional level or national level. A national ISP will cater to the entire nation, as well as the regional or local ISP will provide internet connectivity to a limited geographical area. Then ISP can provide different types of services like dial-up access, broadband, cable, DSL and other type of access. Further, some ISP provide additional services of web hosting, data center services, email solutions, social media, etc. And therefore, it is very difficult to categorize internet service provider from any other kind of service provider, because sometimes ISP doesn't do only the ISP function, but sometimes they host the website also. Now, because they play different kind of functions, therefore it is important to talk about their liability also. Now, there are different kind of arguments relating to liability of ISP. Prominently, we will here discuss two arguments of liability, that is argument for and argument against. In argument for liability, it has been said that ISP should bear the liability on the grounds that it is difficult to identify the culprit in cyberspace, because cyberspace provides anonymity. So, many of the time it happens that a crime or a fraud may happen from different jurisdiction, and it may affect the other party in the other jurisdiction. So, it is very difficult to identify them, and many of the crimes in cyberspace are happening because of this anonymity issue. Now, because we can't identify the culprit, but we can always identify the internet service provider, therefore ISP should be made liable. Now, this is one argument. in support for the liability of ISP. The other argument is that of economic resource of ISP. Now, there is no doubt that ISPs are big corporate in compared to the culprit, or in compared to the individual culprits. They have much economic resource to compensate any damage, if any, in cyberspace. And due to this economic resources, it has been argued that they should be made liable. The next point is that ISP is actually in position to supervise and control the different kind of activity which are happening in cyberspace, because it allows the transmission to happen, because it performs like a carrier, and therefore it supervise and control the information which is being transmitted through ISP, and therefore they should be made liable because it is his negligence and or unwillingness to perform which makes it which cause some kind of damage to the other party. Though on the other hand, relating to the liability, there are points in argument against the liability also. Now, in fact, there are two important, very justified grounds in support to it. The first one is that ISPs are only passive carriers, and they don't do anything more than just accessing or passing through the information which the receiver asks for, and therefore they are only the passive carrier. They don't modify it, they don't alter it, and therefore they should not be made liable for any kind of information or third party information violation. The second ground is that at this point of time there is voluminous data which is being generated in cyberspace, and innumerable transactions happen in cyberspace, and therefore it is impossible on the part of ISP to track down or to scrutinize each and every kind of information, even if it is a third party information or the violation of third party information, and to some extent control and supervise. And therefore it has been said that ISP should not be held liable, because it is impossible at this point of time to control and supervise the cyberspace. Whatever may be the argument or justified argument in favor of and against the liability, but there are two important theories of liability in case it is to be applicable on ISP, which has been supported by various legislation. In this particular slide, I am just mentioning the ratio or the grounds on the basis of this, on the basis of which the liability of ISP can be fixed. The first one is absolute liability or strict liability, and the second one is fault liability, which is basically based on intention of ISP. Now, absolute liability, we know that in case any wrongdoing happening, the ISP will be made liable even if they have the knowledge or not, because the violation is happening, they can be made liable. Second one is fault liability. In fault liability, again it is divided into actual knowledge or the constructive knowledge. The intention part in the fault liability is divided into actual knowledge or the constructive knowledge. In many of the cases, if the ISP has actual knowledge of the violation, then they have the responsibility and duty to stop any kind of violation or to control it. If they don't, then they have the liability according to the actual knowledge, up to what extent they know that violation might be happening in the cyberspace. And in case of constructive knowledge, it is presumed that on reasonable ground that the ISP should be performing diligently to control and supervise the different source or different kind of information which are being passing through him, and so he should be diligent in controlling and supervising the kind of information through his services. So, on the basis of that, liability can be fixed. Now, that was all about different kind of arguments. At the same time, if liability is fixed, what could be the best way to impose the liability. Now, coming to the real legal position relating to the liability of ISP around the European Union, on USA and India. Starting with European Union. Now, European Union has a horizontal approach towards imposing the liability relating to ISP. They define the liability of ISP in Directive of Electronic Commerce 2000, and this directive is applicable for every other kind of offense or wrongdoing which is happening in cyberspace if ISP is party to it, according to the principle which is enshrined in this directive. Now, Article 12, Article 13 and Article 14 of the directive impose the liability on the basis of the principle on the ISP. Article 12 talks about mere conduit and it says that service provider shall not be liable in case it fulfills three important conditions. The first condition is that it does not initiate the transmission, it does not select the recipient of the information, and it does not modify or alter the information. So, if the ISP is in no way deciding the recipient, transmission or controlling in terms of modification and alteration of information, then any information, whatsoever kind of information passing through the ISP will not be liable, even if there is a violation of third party information. Then Article 13 of directive talks about the concept of caching, and in this case ISP are exempted from liability for caching on the condition as follow. The first one, that the provider does not modify the information, the provider complies with conditions on access to the information, the provider complies with rules regarding the updating of the information specified in a manner widely recognized and used by industry, the provider does not interfere with the lawful use of the technology, and at the end, on receiving the actual knowledge that the original source of the information has withdrawn or removed the information, the service provider act expeditiously to remove or disable access to the information stored. So, if these 5 conditions are fulfilled, even if it is a case of caching, ISP will be exempted, because in no way during all this process ISP is involved intentionally to modify the information or to alter the information. In fact, whenever he gets to know that any information is a violation of any particular law or a third party information, and if he gets to know, then he act expeditiously and try to take out that information from the website. It can be done through making request to the ISP also. The party can always make a request to the ISP that his information are getting violated, or something is, he is suffering some kind of loss. Then on that actual knowledge, ISP can always take out the information. Now, how expeditiously he works or to take down that information, that will decide the liability of ISP. Then the last one is Article 14 talks about the hosting. Now, ISP many times, apart from providing or accessing the information, also host the information. So, according to Article 14, there are if these conditions are fulfilled, then he will not be held liable for any kind of liability. The first one, the provider does not have actual knowledge of illegal activity or information, and as regarding claims for damage is not aware of the fact or circumstances from which the illegal activity or the information is apparent, or the provider upon obtaining such knowledge or awareness act expeditiously to remove or to disable access to the information. So, it is the ignorance of the information which escape or which prevent the ISP in the capacity of hosting the information on the website. Coming to US, US has a non-horizontal approach to decide the liability of ISPs, saying thereby they have different acts enacted which talks about the liability of ISP. So, there it depends from act to act how ISP's liability has been defined for different kind of offense or crime or third party violation. Now, in case of defamation, US court in case of CompuSurvey held that ISP had no editorial control over such publication. It is only the distributor and not the publisher of the information, and therefore, based on this particular two reasoning, they exempted the ISP from defamatory statement on their website. Further, later on in the case of Prodigy Services Corporation, the court adopted a different view and held that Prodigy had sufficient control over its computer editorial bulletin board, and therefore, any information which is there on the editorial board, it is under their control and supervision, and so they will be held liable for the defamatory statement. Now, these two cases created a confusing situation for ISP's role in the case of defamatory cases. To provide a final solution, US enacted in 1996 the Communication Decency Act 1996, and under section 230 C, it immunized the ISP from liability as no provider or user of an interactive computer services shall be treated as the publisher or the speaker of any information provided by another information content provider. So, this act by this provision exempted ISP from any kind of defamatory statement liability. Now, coming to the copyright case, Digital Millennium Copyright Act 2000 has provided safe harbor to the ISP on the basis of some conditions, and therefore, there are four important conditions, four important points which we need to discuss here. Section 512 of DMCA is very important in this regard. Section 512A of DMCA allow the service provider to transmit, route and provide connection services to the user. During this course of action, if the copyright infringement occurs due to the intermediary and transient storage of copyright material, then ISPs are exempted if service provider has not initiated the transmission, it is the result of automatic technical process without any interference of the service provider, no selection process from the service provider, and the last one, material is transmitted through system without any modification of the content. So, this part shows that till the time ISP does not interfere with the transmission of the services or information, he will be exempted under this particular clause. Then coming to the other clause or second safe harbor clause, that is in the form of section 512B, it exempt ISPs in case of caching if it provides or if it fulfills the five important conditions. The five important conditions are: first, the origin of the material should not be the service provider, the storage is carried out by automatic technical process without the interference of service provider, no modification of material or content of information. Next, the provider should comply with the data communication rules relating to refreshing, reloading and uploading of material and does not interfere with the technological used. And the last one, the provider expeditiously follow the takedown notice and remove infringing material. So, if it fulfills these 5 conditions, then for caching the ISP are exempted from any kind of liability. Then the third safe harbor is related to storage of information on network at user's discretion. Now, at a user's discretion, because the things are stored at user's desktop, up to what extent ISP can be exempted from this kind of liability, the third safe harbor points to that particular issue. Now, exemption is allowed if 4 important conditions are fulfilled. The first one, the provider does not have any actual knowledge that the material is of infringing nature, and after acquiring the nature or awareness, act expeditiously to remove or block the material for further infringement. Second, if the service provider, by providing this facility of storage, has the right and control over such activity and does not receive a financial benefit directly attributed to such infringing activity. Third one, where it takes step to the takedown notice and block or remove the infringing material. And the last one, provider appoints the public designated agent to receive notification relating to infringing material. If these 4 conditions are fulfilled, then even for storage of information on behalf of user's discretion, the ISP will not be responsible. Or now, coming to the last safe harbor, that is in the form of information location tools. According to it, ISP will be exempted if 2 conditions are fulfilled. First, he does not have the actual knowledge of nature of material, that is infringing one. After acquiring knowledge, remove the link or disable the material available. Second, it does not receive financial benefit attributed to the infringing activity, even if it has the right and the ability to control such link. This is in section 512D. So, if these 4 important harbors are taken care of, then the related activities, if they have been happening through ISP and third party violations, third party copyright violations are happening, then ISP will not be made liable. So, this is very comprehensive in fact legislation on the ISP liability so far. Coming to the liability of ISP in Indian context, we have to see section 79 and the Information Technology Intermediary Guidelines rule of rules 2011 of IT to understand comprehensively as to the liability issues of ISP in India. Now, starting with section 79, exempt or as per section 79, it limits the liability of intermediary if the function of intermediary is limited to providing access to a communication system on which the third party is transmitting information, or the intermediary does not initiate the transmission, select the receiver of the transmission, select or modify the information contained in the transmission. And the last one, the intermediary maintains due diligence while discharging this duty. If these 3 important conditions are fulfilled given in section 79, then ISP cannot be held liable for any kind of information being transmitted through ISP. Though the section talks about intermediary as a whole, since we have seen in the definition part, internet service provider is part of intermediary, and therefore this section is equally applicable to them. However, the third part of section 79 provides exception. In those cases, ISP can be held liable, and the 2 important category of that nature is, the first one, if the intermediary conspired or abet or aid or induce by means of threat or promise or otherwise commence the unlawful act. Second, after receiving knowledge of wrongdoing or notification or notified by the appropriate government, the ISP failed to remove or disable access to that material, then ISP can be held liable for the information. Now, because in the second part the ISP is taking active participation in doing copyright violation or creating any kind of violation of law in cyberspace, therefore, they will be made liable, otherwise not. Then further, the intermediary guidelines rule 2011 to a great extent provide the procedure and provide more insight into the liability of ISP. The guidelines prohibit the user not to host, display, upload, modify, publish, transmit any information which belongs to other, grossly harmful, defamatory, obscene, violate the privacy, racial, ethical nature, etc. Second, ISP shall publish rules relating to privacy regulations. That is very important. Next, ISP to act within 36 hours to disable the information if they acquire the knowledge that information contained therein is of the above category, saying thereby it is harmful in nature. Further, the information is to be preserved as a record for 90 days for investigation purpose. In case of non-compliance with the intermediary rule and rules according to the guidelines, the ISP can terminate the access of user's right of the user to the computer resource of intermediary. And the last one, ISP shall cooperate with the government agency who are lawful authorized for investigation, protective and cyber security. So, this is all about ISP liability from Indian context, and we can also see that our rules to great extent also falls in line with USA and European Union's rule, saying thereby we also talks about the net neutrality of ISP. Till the time ISP is neutral in performing his duties, he will not be held liable for any kind of third party damages. Thank you.